Happy Wednesday, everybody. I hope all of you can hear me all right. For those who don't know me, I'm Patty Anderson, CAE, and I am a WSAE team member. And it's my pleasure to welcome you to WSAE's October 11th, 2023 Shop Talk. We are especially excited to have a number of association professionals present today who are WSAE guests. So welcome to all of you. As a reminder, Shop Talks deliver practical learning for busy association professionals. Experts, thought leaders, and practitioners from inside and outside the association world share what works. If you want to spend a short amount of time learning, connecting with peers, and learning more about what WSAE does, we look forward to your joining more of our regular monthly Shop Talk offerings. WSAE and all of its programs wouldn't be possible without the successful without the support of our Diamond Gems partners. Thank you to Seattle Southside Regional Tourism Authority and Tulalip Resort Casino. All of your support is so greatly appreciated. For those of you that are needing continuing education credits, today's Shop Talk qualifies for 1 CAE credit, not our normal 0.5, since this is a special extended program. And during today's session, again, you are all encouraged to be present by being on camera, display your name and organization on screen, and don't forget to use that chat function as well as the reactions tool to engage throughout the program, particularly if you have a question or comments you want to share. So with the housekeeping matters accomplished, let's jump in and discuss today's topic, which is key legal issues for nonprofits when it comes to generative AI. We are very lucky today to have a special guest presenter, Jeffrey Tenenbaum of Tenenbaum Law Group. Jeffrey is one of the nation's leading nonprofit attorneys and is also an accomplished author, lecturer, and commentator on nonprofit legal matters. As managing partner of the Washington, D.C.-based Tenenbaum Law Group, Jeffrey counsels senior management and boards of directors of his clients on the broad array of legal issues and sensitive business and governance issues that affect trade and professional association. He is widely regarded as an innovative, responsive attorney with great judgment who provides practical and understandable advice extending to virtually every nonprofit legal issue and best practice. I have had the opportunity to know Jeffrey for a number of years, but what stands out most to me regarding him is the vital role that he played in helping associations navigate through the COVID-related governance and event planning trials and tribulations of just a few years ago. So please join me in giving a warm WSAE welcome to Jeffrey Tenenbaum.
Thank you, Patty. Welcome, everyone, or thank you for having me today. So today we are going to be talking about generative AI and associations and how your associations can mitigate your legal risk. I want to encourage you to please unmute yourself, interrupt, and ask questions at any time. I don't want to save questions for the end. I really want to make this as interactive as possible. I don't have a prepared speech, so to speak. I definitely don't have a PowerPoint, but I do have, some key points I want to make, which will hopefully stimulate some ideas and questions and comments on your part. And I want to make this as interactive as possible. I have spent my whole 27-year legal career as an attorney in private practice in DC, all of it exclusively representing associations and nonprofit organizations. I was at a large firm for most of my career. Venable chaired the nonprofit practice there and started the now 5-lawyer boutique firm, Tenenbaum Law Group, almost 4 years ago. We represent about 700 associations and other nonprofit clients on a broad array of all of their different legal issues, including, of course, counseling them in legal issues relating to the use of AI. So first off, there is an article of mine on the topic that ASAE published and American Bar Association published and a number of other places called Generative AI and Associations, 5 Key Legal Issues to Consider. I know Patty's going to circulate that to everyone after the program or tomorrow or at some point. So you'll have that as a resource. I also sent to Patty that she can share with you a model kind of association generative AI employee usage policy. Um, it's the first one that we worked on for a client, but really, frankly, we just reviewed it for a client and then edited it and added some stuff to it. It's a good start. It's not the end all be all perfect. I don't think there ever will be. It'll be constantly evolving, but I think it's a good start. And I think no matter what else at the end of this program today, you're going to walk away from it after this webinar. You're going to walk away from it realizing that we need to have something in place governing AI usage by our staff. And as I'm going to talk about, by others as well, but especially your staff, because, or for those that, some of you might be just a one-person shop, some might have multiple staff, but pretty much anyone these days working for an association, there's a high likelihood that they're going to use generative AI at some point in their jobs. And that creates potential legal risk for the association. And so what you really need to do is have a policy that governs that usage. So what are the legal risks of generative AI for associations? Well, we know from a positive perspective that generative AI, I'm just going to refer to it as AI, has so many potential benefits for associations, some that we haven't even started to think about yet. But just like it has so many potential uses and benefits throughout all aspects of society, that applies to associations as well. And everything from your operations and management to all the important programmatic work that you do for your members and the professions and industries that your associations represent. And there's so many great things that can come from it. But like any other great thing, any other thing generally, there's always legal risks. But the good news is there are ways to mitigate that legal risk. You can never quite eliminate any legal risk. And all of these legal risks, like for instance, when I was writing this article that I referred to, all of the areas of law, and I'm going to go through those kind of 5 legal issues, none of them are new. There's no new areas of law. I mean, at some point, it is highly likely that there will be federal regulation of AI. But now that regulation is likely more to apply to kind of the AI developers and operators, as opposed to the users, but it'll have effects and implications for all users of AI. But for now, the legal issues aren't new, but like everything else, how the application of AI to these legal issues does create legal risks. And it also creates ways for you to understand how to mitigate those risks. So I'm going to go through kind of each one of these 5. The first one is data privacy. Now, this may or may not be a legal risk for your association, depending on how you use AI. So for instance, if your only use of AI is to, put questions into something like ChatGPT, I'm just going to use that, probably throughout as an example, but there's so many different good platforms out there. If you're just using it to ask questions and brainstorm ideas for new articles or other things that you're putting together as staff of an association, it's not going to generate any data privacy concerns. But other associations, and associations are starting to do this, especially associations that deal with large data sets, and whether it's member data, whether it's data from conferences, publication sales, you name it. There are ways to use generative AI to help analyze that data, to help sort that data, to help do all sorts of things with it. But whenever you are putting data into a generative AI platform, in most cases, you are kind of putting it out there for the world to potentially see and use, because that's how generative AI works. It takes everything, it learns from everything that gets put into it, along with millions of other things, and it keeps learning and growing from that. So you kind of lose all control and protection in most instances, and I'll explain what I mean there. So you need to be very careful that whatever you and your staff, your colleagues are putting into an AI platform, that it's not sensitive data, that it's not protected, that it's not subject to the attorney-client privilege, that it's not subject to a non-disclosure agreement, other things like that. It could be sensitive member data, contact information, other things like that, credit card data. or you're not likely to be putting credit card data into ChatGPT, but there can be a lot of data that you guys might want to put into a platform to help you analyze it, sort it, understand it, etc. And you need to be very, very careful when you're doing that. There are ways, and I'm not a tech expert by any stretch, but I have heard that there are ways that you can help mitigate this risk. For one, I understand, and don't quote me on it, that there is a more enhanced version of ChatGPT that you have to subscribe to. There's several versions, and I don't know which one or ones this applies to, but there's one or more version that it's a paid subscription. But when you subscribe to that version, there's an option that you can select that whatever you put in, data, content, anything else, is not going to be shared and used. It's just going to kind of stay within your own usage of that AI platform. In addition, I understand that this is going to be something probably really more only applicable for larger associations, but there are kind of enterprise versions of AI platforms where it can just live on your own servers and never leave there. Again, something that's going to be more expensive, you're going to have to pay for. But if you are able to, if Kylie and Teresa, if you can mute yourselves, that'd be great. And if you're able to afford to use those things and subscribe to those in a way that will help mitigate those risks, it's highly advisable to do so. And then, of course, you need to make sure that your employees, if you have other staff, are only utilizing that sort of a platform and not just going themselves onto Google and going out and logging onto one of these platforms and doing it on their own. You want to make sure that all usage kind of feeds through that specific platform. So that's one area, data privacy. Another area kind of related to data privacy, but certainly different, is intellectual property. For associations, we're usually talking about two forms of intellectual property. We're talking about copyrights and trademarks. Now, mainly in this area, we're talking primarily about copyright issues. So first off, several different things to think about here. When in copyright, whenever I give speaking presentations about copyright law, I always talk about the fact that you're looking to, number one, protect and maximize your rights to the copyrights and works that you own as an association. And number two, you're looking to ensure and help make sure you don't infringe anyone else's copyrights. And both of these things are equally important. So on the maximizing your rights, and as I talk about whenever I give speaking presentations on copyright, one of the ways of maximizing your rights is making sure that you have a copyright assignment or a license from anyone who is creating copyrightable works for your association. So the Copyright Act says that whenever an employee is creating a copyrightable work within the scope of their employment, it's automatically owned by the employer if it's within the scope of their employment. But for anyone who's not an employee, a contractor, a volunteer, like a member who's a writer for your newsletter or a speaker at your conference or meeting or webinar, for all of those, they are the ones that automatically own the copyright in anything they create. So you want to make sure that you always get either a copyright assignment, like from a consultant or a vendor that you're hiring to create some work for you, whether it's some text, an article, a book, a technical manual, software. You want to make sure you get a copyright assignment, which means a transfer of ownership from anyone you're paying to do that. And for volunteers, it's going to be hard to get an assignment, but you can generally get a non-exclusive license, which means permission to use. So you get a license from your volunteer authors, speakers, committee members that are creating copyrightable works, even board members and things like that. And that's always really important to do. But so that's one aspect of maximizing your rights. Other things you can do, use copyright notices, make sure you register works with a copyright office. But the Copyright Act says that in order for something to be registered with the Copyright Office, it has to be, among other requirements, a product of human creation. It has to be a product of human creation. Something generated by ChatGPT is not going to be a product of human creation. And so what you want to do, not just because you want to maximize your copyright rights and want to be able to register things with the Copyright Office without violating the law or having those copyrights subject to challenge later, is you want to make sure that any time that you, your colleagues are using an AI platform to generate content, that it is, after that content is generated, it is sufficiently modified to become a product of human creation. Generally speaking, that's not going to be that difficult to do. For those of you who use someone, I just gave an interview to a reporter for CEO Update earlier today about AI and associations and legal issues. And he was asking me if I ever use AI or my colleagues in our law firm. And I said, generally, not really in our work we do for our clients, but once in a while when I'm writing articles and I'm trying to brainstorm, and he referred to it as kind of writer's block, like if you're just trying to brainstorm ideas for an article or something like that, using ChatGPT or other platforms can be really helpful sometimes in doing that. I even did it when I sat down to write the article about AI and associations and legal issues. I asked ChatGPT, what are the top legal issues that associations need to deal with in the use of generative AI? And it gave me, a few sentences here or there. It was a good, helpful starting point. It wasn't nearly everything. It wasn't complete. It didn't give me much detail. But it gave me, a good starting point. And of course, everything I ended up writing was very much a work of human creation and my own work. But using it in that manner is fine. Just make sure, sometimes though, for more technical things or whatnot, there might not be a lot of modification needed. That doesn't mean that's necessarily a problem. If it's just something for your own internal use in your association, maybe it's not a problem. But in other areas, like for instance, if you do want to register with the Copyright Office, that can be very much an issue, like a technical manual or something along those lines. And I'll talk in a minute about another area of liability risk where that can be a problem. And then the same thing goes for your volunteer speakers and authors and even contractors. You want to make sure that they are representing and warranting, these are legal terms, in the speaker agreement and the author agreement and your independent contractor consulting agreements and any other documents that are dealing with kind of copyrightable content, that they are representing and warranting to you that this is their own original work. That's something that we've had in our standard speaker and author agreements for decades, frankly. But it has got a new meaning with generative AI these days, and we're starting to modify those forms to kind of put that in there even more specifically. Once in a while, there might be a reason that you actually want to use something that came straight from the AI platform without modifying it. That's okay, as long as you're not trying to register it with the Copyright Office, but just make sure you put a really strong disclaimer on there that says this is a product of ChatGPT solely. And so that's kind of some of the basic copyright issues, intellectual property issues. And of course, just like we talked about with data privacy, any content, any documents that are subject to the attorney-client privilege, or they're otherwise confidential or subject to a non-disclosure agreement, or trade secrets or things like that, you certainly want to make sure you're never inputting those into a generative AI platform, unless you know that platform is self-contained and it's not going to be shared anywhere. Another area of liability risk for associations is tort liability. So tort liability, torts is a class that every law student takes in the first year of law school. And what it basically means is liability that an individual or a company or an association, for instance, can have from, in most cases, being negligent. It can come from intentional misconduct and whatnot, but generally we're talking about negligence. And in this context, so for instance, classic tort is like a slip and fall accident. Association has a meeting. The association is negligent in how it sets up the meeting room, or it doesn't have proper cleaning of the floors, or sometimes it might be a joint negligence between the venue, like the hotel, and the association. But associations, if they're negligent in how they conduct a physical meeting and it causes some physical harm to someone, the association could be held liable for negligence, a form of tort liability. Similarly low, that's physical injury, but economic injury can happen from association activities when associations put content out there. Think manuals, guides, how to model contracts and forms. These are all things that associations do all the time. Setting standards, having a certification program, accreditation program. Anytime you put these things out there and you ask your members to use them or rely on them, or you're telling the public, look, by using a certified, a certified individual or company or a member of our association that has to abide by an enforceable code of ethics, that by using a member or a certificate like this, you're getting a much higher standard of quality, they're better trained, et cetera, et cetera. Well, if it turns out that you're negligent in how you do that, or the standards that you set, or the manuals that you put out, and it ends up causing someone some economic harm or physical harm, then the association can actually be held liable for negligence in that regard. I'm not going to get any more into the details of tort liability, except to say that if you are using generative AI to help generate some of those technical manuals or standards or guidance that you're putting out there and asking your members or the public or others to rely on, and it turns out to be negligent, you can be held liable. And so just like anything else that you put out, it's really important that you do your due diligence, you do your homework. If you're going to use a generative AI platform as a starting point for something to help sort data, to help run formulas or other things like that, that's fine. But make sure, again, that you are doing sufficient work on your own or with your contractors or your experts or whoever to be sure that you're not just relying on what gets spit out from a tort liability perspective. Another interesting to me from a legal perspective area of liability is discrimination, especially in the employment setting. So I'll give you one example. Employers, some associations, for sure, some larger ones, I've heard this already, but certainly, much larger, say, corporate employers are now regularly using generative AI platforms to help screen resumes, because they get hundreds or thousands of resumes for open positions. So they're using AI platforms to screen resumes, and then sometimes even to take it a step further. There was an article I read in the Washington Post about this a few months ago, and it gave a whole bunch of examples. And some companies, they use it to screen the resumes, and then once they whittle that down to a smaller stack of resumes, then they reach out to those candidates and they have them all respond to a set of preset questions, and they record the answers to those questions. And then the companies use an AI platform to analyze those recorded videos of the candidates responding to those questions to kind of then weed through and figure out, okay, who we're going to interview in person. Because these platforms inherently have some bias built into them, because they're relying on so much data, content, information that's out there publicly on the web and elsewhere, that itself is the result of decades and hundreds of years of bias kind of built into things, that if your use of the AI platform in the employment setting ends up, the AI platform that's screening recorded videos has trouble understanding someone's heavy accent or speech impediment, and as a result, they don't make it to the next round, they get weeded out. Could that person end up suing for discrimination on the basis of a protected characteristic? Yes. And these lawsuits are happening. They have already started. Similar things could happen if you're using AI to help evaluate employee performance, like in the employment and performance management setting, and other things like that. So it has some real potential consequences, and you really need to be careful. I'm not saying it can't be done, but you need to be really careful and build in guardrails to help really mitigate that risk. And then finally, while it's not a legal issue, because these sorts of discrimination claims are generally limited to the employment setting, although not always, but generally they are. But even in like your volunteer management, like some larger associations that have very large pools of volunteer leaders, they have hundreds of whether it's say at the chapter level and committees and councils and House of Delegates and some very large, especially national associations, have really robust governance structures and hundreds of actual and potential and past volunteer leaders. And they need ways to organize that and to sort it and help identify, okay, who'd be a good candidate for this committee or that committee, or who might be a good board candidate or things like that. And again, if you're using AI to help screen people in that way, and it ends up having a discriminatory impact, likely not illegal, under most federal and state laws, but certainly problematic from a member relations and a public relations perspective, and something you really want to be careful about. And I say generally because there is one federal law. It's section U.S. Code section 1981. It's been around since the end of slavery, and what it prohibits is discrimination on the basis of race in contracting, making contracts in the federal, state, or local level. It was designed to help make sure that former slaves weren't discriminated against in contracting, and it's been around ever since. It only applies to race, not to other protected characteristics. But there's a companion set of lawsuits that were filed by the same plaintiffs that brought the case that the U.S. Supreme Court decided again about race-based admissions, and using essentially the same rationale of the court's decision in those two cases. It filed lawsuits against two large law firms that have fellowship programs that are limited to law students and lawyers in certain disadvantaged categories, based on race and ethnicity and other protected characteristics. They're not open to anyone. They're only open to those categories. Think similarly of association, scholarship or fellowship or internship programs. Anything that has a contract that's required, and almost all of these things do. Even a scholarship and other things like this typically has a contract attached to it. And the lawsuits allege that it's illegal, essentially alleging reverse discrimination by excluding white people and others from these law firm fellowship programs. And again, to the extent that associations engage in programs like this that involve contracts, it creates, we'll have to see how the U.S. Supreme Court rules. I have no doubt these cases will make it to the U.S. Supreme Court. But again, if you were using AI to help screen people for certain things like this, it raises actually another area of legal risk for your association. And then finally, the last category I wanted to mention is insurance. Like any other legal risk, you can do all these things to try to mitigate it, but you can't eliminate it completely. That's one of the reasons why you have insurance. There's not one type of insurance. Most associations have about 5 or 6 or 7 types of insurance, from commercial general liability to property insurance to cyber insurance to directors and officers liability insurance. All of these types of insurance are good and important, but none of the ones I just mentioned are going to protect you against most of the claims. They will protect against like employment discrimination claims, but they won't protect against most of the other claims. So cyber insurance will help in the event of data breaches and things like that. But some of these tort liability risks and some of these other risks that are kind of AI specific are likely not going to be covered by or going to be excluded by all or most of those policies. So what you want to really do is work with your insurance broker to be sure that you have sufficient insurance to cover all of these risks. And the one type of insurance that I think every association should have, but most in my experience don't, is what's either called an errors and omissions liability insurance policy, or sometimes called media liability insurance, sometimes even referred to as professional liability insurance, although some D&O policies are also called professional liability. But basically, it's designed to cover the sorts of claims and risks that are not going to be covered by most D&O policies, something you really want to look at. And then, finally, like I alluded to earlier, in order to help deal with all of these risks, you really want to be sure that you codify all of this in policies, in written policies. an employee usage policy for AI and make sure it's enforced. Building these sorts of provisions into your contracts with speakers, authors, vendors, consultants, etc., making sure those are enforced. And then publicizing these rules and perhaps updating clauses in contracts, all of which I mentioned earlier. These are all going to be really important ways to help mitigate your risk. So that's what I wanted to talk to you about today. Let me stop there and see if anyone has any questions or thoughts that they want to share.
Yeah, to help during the question and answer period, if you do have a question or comment for Jeffrey, if you wouldn't mind raising your hand, and then we can call on you as we go through. I will say, Jeffrey, you made a comment about not encountering many associations that have errors in emissions insurance. I have to say that in a previous life of mine, the association management company did require that any of its organizations that it represented that had like a certification or standards program, that they do, they would require that those organizations, in order to work with the AMC, would have an E&O policy. So that's interesting that you're still experiencing.
Well, no, you have a certification or accreditation or standard setting program. Yeah, there's no question your insurance broker would be super, super negligent if she advised you to get an E&O policy, because those sorts of claims are always excluded from every D&O policy. But there's a lot of associations that don't engage in certification, accreditation, or standards. Yeah. But still, they do, so standard setting is classically used in, ways to mean, we're setting these standards, either they're voluntary or they're mandatory. But a lot of associations put out guidance, in the form of just articles or a manual. You might not consider it standard setting, but it still has the potential to create tort liability risk. And that sort of tort liability risk is generally going to be excluded from most D&O policies. Right. Yeah. You have a question?
Yeah, Monette, would you like to?
Yeah, I was really interested and thank you, this is really helpful information, but you were mentioning that with the Copyright Act, making sure that you change the data enough after output to make it a human product. But I was kind of curious about how significant the degree of human input prior to generation in establishing this content counts as a product of human creation. Has it even been out long enough to be able to say that yet? Because I feel like there's a certain level of, if you put in so much information in the prompt to rely on that output, does that have any impact on that copyright law?
It's a great question. The answer is no one has the answer to that right now. But even the U.S. Copyright Office, who doesn't have the answer to the question, actually just about a month ago published a notice in the Federal Register all about AI and copyright law. They're basically asking a whole series of questions, and they want feedback and input so that they can help sort out questions like that and plenty of others. So they recognize that. That's a good thing. I don't remember the last time the Copyright Office was that kind of proactive in doing something like this. And so that's, that's a good sign. And what it probably means that eventually it'll be a while that we'll have better guidance.
Thank you.
Jeffrey, what is your experience so far in terms of organizations using AI platforms to generate notes and minutes from meetings?
Yeah, a lot. I see it all the time. Sometimes you see it on, we're all looking at these boxes on the Zoom screen, and there'll be, a box that says, Patty's bot, or something like that. And sometimes even like for Zoom meetings that I host, it shows up on my inbox that Patty has joined the meeting, but then it also say, Patty's bot has joined the meeting, and things like that. So I know it's being used all of the time for note taking. In and of itself, it's really no different than recording it, like so many folks do. But what I will say is that because of the ease of recording meetings, both transcripts, through a bot, and video recordings, it's happening more and more. But there are some cases. Now, a webinar like this is a perfect example of why you should record it, so you can share it with so many others afterward who can benefit from it or weren't able to see it here. But where I start to have concerns is when it comes to things like board meetings and executive committee meetings and other committee meetings and other sensitive meetings where it is generally, I mean, I've been advising on this my whole 27-year career. Even when it comes to meeting minutes, I've always advised that meeting minutes of board meetings, committee meetings should really, so many meeting minutes are way too long. They should not be a transcript of who said what. They should just talk about the actions that were taken. The board discussed XYZ and then it voted to do ABC and things like that. This committee chair gave a report on this committee chair gave a report on that. Obviously any motions or votes should be recorded in there and nothing more. And there's a whole host of legal and other reasons why it can be very dangerous to put more than that in there. Now, some association clients have asked me, are you okay, Jeff, if we record the meeting solely for the purpose of the secretary or whoever else who's going to be writing up the minutes to use it as a reference and then delete it right after? And, if someone feels the need to do that, I can live with that from a legal perspective, but you need to be sure that you're deleting those recordings right after. And frankly, the same would go for a transcript that's generated by a bot. No, that's for meetings and things like that. If, on the other hand, like I'm on Zoom calls all day long to give advice to clients. And sometimes my clients want to share that advice with others. They want to show others the recording or have the transcript from the bot, or the notes. I know different ones of these do it in different ways, but, have the bot generated notes to be able to share with other people or for their own reference. That, no problem at all. No issue at all. But keep in mind, your guard should go up if you're regularly doing that for board and committee meetings and not destroying them afterward.
Yeah, the reason why I ask is one of the trade organizations I work with has a very strict antitrust policy. And, they really worry about, people in their committees and board calls getting into those pricing or market conversations. And so they have said no recording of minutes, and now saying no, not even AI recordings, so.
I do a lot of work in the association antitrust area. And that's actually one of the classic reasons why you don't want too much detail in your minutes and you don't want those meetings recorded. I was at a meeting last week, a board meeting. Well, I won't even say where, I'll just say California. And the board was meeting and I went to do like a board governance and legal training session. But then afterward, someone started talking about something and he said, wouldn't it be great, if we could all just, charge, X amount more for this, because we're taking a hit, on this big promotion every year. And it was my first meeting for this client, by the way, and I wasn't even there to give antitrust advice. But I had to, he said something and then someone else started talking about it and I chimed in and I said, you can't talk about this. You just can't talk about it. Because, later, and there have been plenty of antitrust cases where later, if all of the members of this industry, or at least the board members around the table, ended up raising those prices, by that same amount of percentage or whatever, and the antitrust regulators or plaintiff could go back and get a transcript of that meeting or notes that were generated by an AI bot and see that discussion, that's hugely problematic. That's like Exhibit A in a price fixing case. That's not what you want. Now, granted, could someone still, subpoena someone and force them to give, a deposition to testify on what they heard in the meeting? Sure, that can always happen, but it's not nearly the same people's memories as if you were having a transcript or notes generated from the meeting.
Great, thank you. Okay, you've got to have more burning questions. Scott, I know before we started, you said you might have some.
Oh, I was joking.
Oh, okay.
I actually don't have any. I mentioned that I couldn't come up with any questions, so I used Chat GPT to generate some. So just trying to be funny.
Kim, go ahead.
All right. Are there any cases where you might want to feed data, like maybe about our association, into Chat GPT to give it that information?
An interesting question. I never thought about that. Just
I just did it because I just searched who is Wafla and it didn't have anything. Then I fed in our general information from our website and then I asked it again and it popped up all our information.
I think it's a great idea. As long as you
Yeah.
follow ground rules about, don't think that's sensitive or confidential or
Yeah.
protected, infringes anyone's copyrights, but just basic information about your association. I think that's brilliant. I love that.
Mm.
So many of the search engines like Google are now using, their AI platforms to help in Google search, things like that. And it very well could help. Bring if you put it into whatever it's called, Bard, I think is the Google one. It might help with your search engine optimization. All right. Well, if no other questions,
Looks like Vanessa made a last minute question.
Hey
Vanessa?
there. Yeah, sorry. I came late to the party. I had another call on the top of this, so you may have already covered it. As a consultant, I'm wondering, is it a good idea for associations to make sure that their consultants have legal language around this in their contracts and the deliverables that they're producing? Is that something I need to start worrying about?
So, I represent mainly associations and nonprofits. Although once in a while I represent some of the larger consulting firms and whatnot that work with associations, as well as some like association management companies, some of the larger ones. And so, whoever my client is, I want them to have good contracts that have all sorts of things in there. Yes, there should be an AI specific provision in there, depending on the nature of the work and whatnot, but a million other things. And so what we always do with our association clients is to make sure they have one or multiple versions of a really good model kind of independent contractor agreement that you can use with consultants and other vendors. It doesn't always work that way. Like some consultants and vendors have their own contract form and they insist on using that as a starting point. But not always. It really varies. And either way, it's going to be a negotiation and you're going to, whatever side I'm representing, going to try to get the more favorable provisions. But whether it's the association I'm talking to or you as a consultant who I'm talking to, yes, you should have very good templates with all sorts of things in there, including something regarding AI. And the consulting firms that I work with, we've done that with them. It was one of the first projects when we first started working with them, is to make sure they have contract templates.
Yeah, no, I'm thinking more from the association side when they're looking at my contract. Do they need to be looking for this? And then I'll make sure it's in there. But okay.
Yeah, Jeffrey, I think you mentioned early on in the presentation, that you want to make sure that there is language about representing and warranting that the work of the consultant or presenter is their original work.
Yeah.
Or disclose the fact that
in our model consulting agreement for associations, it says the consultant represents and warrants that it's their own original work. It doesn't infringe anyone else's copyrights or trademarks. It doesn't defame anyone. It doesn't invade anyone's privacy rights. Other things like that. And so, yes, this would be one of them. And I don't even know what. We haven't really settled into model language on the AI specific stuff. This is all really so new, but I could see, there needs to be some AI specific language in there. I guess my short answer is I don't know exactly what it should say yet. Scott?
So just as a follow-up to that, are there good ways of checking or I guess gaining some understanding into whether a work has at least some AI generated content in it? I know teachers are interested in those types of tools or algorithms to decide or help them determine if maybe a student has used AI to generate a paper. But what's out there for that type of thing in the not only in the educational world but in the professional world?
Yeah, like I said earlier, I'm not the tech person. I'm the wrong person to ask, but I do know. I just saw my sister-in-law August. She's a high school English teacher in Portland, Maine, and yes, her school has some kind of a software that all the teachers have where they can run those English papers through it to see if it's AI generated. And I'm sure it's not perfect, but I know that that type of software is definitely out there and widespread.
Interesting.
Yeah.
Any other questions for Jeffrey?
All right. Well, thank you everyone for having me. I hope you found it helpful. And
Well, yes, we so appreciate. We'll be able to give a few minutes back to everybody, but thank you so much, Jeffrey, for sharing your wisdom, your experience and energy with us. As a reminder, as a follow-up, I will be forwarding you the link to his art, to Jeffrey's art that he provided me. Also, we will be producing and publishing that article in the next issue of the WSAE magazine, the Washington Conference. Also, I would also encourage you to make sure that February 14th is on your calendar, your 2024 calendar, and that it includes that month's Shop Talk. Jeffrey's going to be joining us once again for another special 60-minute program, and the topic on that session will be steps to mitigate legal risks of association ESG and DEIA programs. So another hot topic that we're all encountering right now.
And I just put into the 3 links that you might find helpful. One is just the main link to our website. One is to a link where we have probably 150 at least recorded webinars on all sorts of association and nonprofit legal issues, and we're constantly adding to that. And then the third one is where we have several hundred articles and PowerPoint presentations on all different association legal issues, and we're constantly adding to that. So feel free to check those on a regular basis if you're interested in that kind of stuff.
Oh, that's so fabulous. So appreciate that.
Absolutely.
Say in closing then that WSAE does have a full agenda of other learning and training opportunities through the rest of this year. Most important, you want to make sure you get on your calendar WSAE's in-depth next level leadership summit. That is scheduled for November 7th, and we're going to be talking about unlocking the inspiration of your board. So please visit the Learn tab on the WSAE website. That's wsaenet.org for complete details or to register. So again, thank you, Jeffrey. Thank you all for joining us. I hope you have a great rest of your day.
Thanks, everyone. Take care.
Thank you.
Take
Thank you,
care.
Jeffrey. Thank you,
Bye-bye.
Patty.